Good morning. Good morning. Welcome to Minden Public Schools. I am Don Hosick. I'm the high school principal. I'd like to thank each and every one of you for coming today. This is kind of a once-in-a-lifetime opportunity for Minden Public Schools to be able to host such an awesome event. And I am as excited as anyone, and I appreciate each and every one of you for coming today. At this time, I'm going to turn it over to one of our outstanding students, Junior Sam Cedarberg, and he'll go through a few housekeeping items. So thank you. Have a great day.
I'd like to welcome you all to Minden Public Schools, but before we get started, we have to go over a few basic courtroom rules. And remember, in a couple of minutes, we will be in a Supreme Court, not our school. If you manage to get in here with a cell phone, please turn it off, power it off, no phones ringing, no selfies, no Snapchats, nothing to do with digital devices. Also, there are no food or drinks allowed in the auditorium. If you have a camera and are with the media or student media, please make sure you have spoken with the public information officer and have been given permission to take pictures. Silence must be maintained during the court sessions. The lawyers presenting their arguments here today have worked long and hard to get here. If you have an emergency and need to leave, try to wait for the break between arguments or wait before the arguments are finished. Once you leave, you are not able to come back until the break after the arguments. I would love to now introduce our local Minden District Court Judge, Terry Harder, to talk about what you will see here today, and again, welcome the Nebraska Supreme Court to Minden.
Good morning. As Sam said, my name is Terry Harder. I'm one of two district judges that serve the 10th Judicial District in South Central Nebraska. And although I'm supposed to talk about the Supreme Court, I'm going to take a minute or so just to give you a little bit of a local civics lesson about your judiciary. I think there are schools here today from Franklin, Kennesaw, Blue Hill, maybe Hastings. I'm forgetting someone, but the list that Principal Hosick gave me, all of you are in the 10th Judicial, live in the 10th Judicial District. So we travel to the county seat of the counties. I go to Phelps County, Harlan County, Franklin County, Webster County, Adams County, Clay County, and Nuckolls County. So we have an 8-county area that we cover. And so like in the days of old where judges rode horses to different counties on your Gunsmoke reruns. We do the same thing yet today, but we don't ride horses. So with that, I want to introduce my favorite colleague on the bench. Don't tell anybody I said that, but I have Judge Tim Haft, who is a county court judge from Holdridge here today, and the county attorney from Kearney County, Melody Bellamy, is here today. There are some esteemed members of our local bar here today. And probably most importantly to me personally is my bailiff, Kelly Hartman. Kelly is the one who actually runs my office. She keeps my calendar. She does everything, and she's good at it. So please give them all a hand. I know you're all not all from Minden, but there are a couple of big things happening at Minden High today. One is the Supreme Court is here, and the second is homecoming. So I know the tendency is to get a little excited for homecoming, but I would ask that you wait for that until after the Supreme Court has finished this morning, because it is a really big deal for them to be in Minden. And the Supreme Court leaves the comfortable confines of the state capitol twice a year to visit the Creighton Law School and the UNL Law School, and they visit one or two high schools per year. So I went online because when I heard they were coming to Minden, I was really surprised because Minden's smaller than the high schools they usually go to. So I looked at a list that was posted, and since 2016, Minden is in fact the smallest town that the court has come to hear cases. So I just want you to appreciate that it is a special event, and you should be honored that they're here, and I personally want to welcome them here. So getting on with what I'm supposed to talk about, my role today is to review with you some information that I'm told you were provided prior today. I'm assuming that your government teachers have spent some time with you on that, and I hope my remarks aren't too redundant, but I'd like to go through some preliminary matters that hopefully will give you a little better idea about what's going to happen today. So as I indicated, the court usually sits in Lincoln at the state capitol, and their offices and their permanent courtroom is there. Can I see a show of hands about how many of you have been to the state capitol? So a good number. And show of hands for anybody who remembers on their tour of the state capitol going to the Supreme Court courtroom. Okay, great. I thought most of the 4th, 6th, 8th grade field trips spent more time in the unicameral, but it's good to see that the Supreme Court was included in those trips. Anyone here ever witnessed a Supreme Court argument before? A couple. All right, but for most of you, this will be a new experience. So another thing you should know is that although people don't really make a habit of going to see a court case or an afternoon of court cases if they don't have some personal interest in the what's going on there, but courts in Nebraska are always open to the public. So on any given day, if you are having a slow day, call my bailiff, and if I'm here or Judge Haft is here, you're welcome to come sit in. Nobody will ask you why you're there. You're just free to come and go as you like. And that's from the Supreme Court to any court in the state. So I don't know if any of you have counted, but the Supreme Court is made up of 7 judges, and so there are 6 judges and a chief judge. Each of the 6 judges represent a geographical area in the state. The chief judge can come from anywhere in the state. Anyone have any thoughts on why there's an odd number of judges on the Supreme Court? Exactly. If you're voting on things, it's better to have an odd number than an even number so we don't have ties. So the Supreme Court is what we call an appellate court, and appellate just means that's where appeals go. Judge Haft and I are trial judges, so appellate judges and trial judges really do very different things. At each hearing or trial that I have, my court reporter takes down every word that anyone says, marks exhibits, and I hear the testimony of witnesses and the offering of those exhibits. And those exhibits can be anything from pay stubs to tax returns. In a criminal case, maybe you got a knife, a gun, bloody clothes. But anyway, the collection of the exhibits and the taking down of the testimony forms what we call the record. And the record is very important if a case is appealed, because lawyers don't get to retry or get a second bite at the apple when they appeal a case. They are stuck with the record that has been developed at the trial court level. So when does an appeal happen? It happens when someone is not satisfied with the outcome at the trial. And as I told you, Judge Haft and I are trial court judges, and we find it hard to believe that anyone would not be satisfied with our final decision, but it happens. So I don't want to get too bogged down with where appeals go from court to court, but as a general matter, know that county court would appeal to the district court appeals would go to a court of appeals. So we have not spoken about the court of appeals, and if they came to Minden, I'd be happy to talk about them, but you do need to know there is a two-level trial court system and a two-level appellate court system. So county courts and district courts make up the trial level, and the Court of Appeals and the Supreme Court are the appellate courts. So if the appeal system is, as I described, how do cases get to the Supreme Court? So cases from the Court of Appeals can be appealed to the Supreme Court, but it's not a right. The Supreme Court has to grant permission and take your case. The Supreme Court also hears death penalty cases, any case in which a life sentence is imposed, and any case that raises a constitutional question. And so those cases would come from the district court. The Supreme Court can also, what we call, reach down to the Court of Appeals and take any of their cases they want. That's what you get when you're the Supreme Court. You get to do what you want. So why would they do that? Well, part of the time it's to simply equalize their caseloads. And if you're one of the attorneys on the cases, when they've reached down and brought your case up, you try not to read too much into that, because it can just be that they want to equalize their caseloads. But sometimes it may be a case of first impression in the state, meaning that there is no case law on it. It hasn't ever been addressed. And so that is an opportune time for the Supreme Court to reach down and take that case. The other way that the Supreme Court gets cases is exactly what Mr. Soucy did in this case that you're going to hear, which is to ask for a bypass. In other words, they came out of district court, and Mr. Soucy asked to bypass the Court of Appeals and go straight to the Supreme Court. And in this case, the court said yes to him. So in that case, that's what happened. All right, so when I'm finished in just a few minutes, the court will come out, and they're going to listen to arguments. There won't be any screaming and yelling. It's not an argument in the usual sense of the word. It is a discussion of the facts and the law of the case that you're going to hear today. And I do have a little bad news to break to you. The Williams case is going to be heard, but the State versus Clark case got continued because one of the attorneys had a sick child. So those things happen, and it's just unfortunate that the court's here and you're here and we're ready to hear two cases, but now you'll only get to hear one. And the court is sorry about that. So at this point, the court comes out, and are they hearing about the Williams case for the first time? Absolutely not. So they have had an opportunity to read the briefs of the parties and do independent research on their own. And remember the record, they've had an opportunity to read everything that was said at the trial court level and review any exhibits that were offered at the trial court level. So briefs are simply a written document containing each side's argument. I don't know why we give everything weird names, but briefs aren't necessarily brief either, so it's not a very representative name of what they are. So you may observe today when the arguments are going on that one of the judges will interrupt the attorney speaking. So we're all taught that that's not really rude to interrupt someone, but we let the Supreme Court get away with it. It's not thought to be rude when they do it. They're simply trying to clarify a point or get more information on something that they think is important in the case and understand the argument of the attorneys better. I remember a Supreme Court argument I did many moons ago. I introduced myself and never got to my well-reasoned, very persuasive argument, I'm sure, because it was just a rapid-fire question after question. And so when you're practicing in front of the Supreme Court, the arguments don't always go as you had them scripted in your head. So you need to be on your toes a little bit. So after the argument, is the Chief Judge going to sit forward and announce a well-reasoned decision on the Williams case? No. The Supreme Court never what we call rules from the bench. They take every case under advisement. They will do a preliminary vote on how they see the case, and a judge will be assigned to write the opinion. The opinion is then circulated amongst the other judges. The author of the opinion will take input from other judges as to maybe improving how it's written or other law that should be cited. Then it's proofed and edited and finally filed with the Supreme Court clerk and then posted on the judicial court website. At that point in time, we know as judges and attorneys that the Court of Appeals posts those opinions on Tuesday, and on the Supreme Court posts them on Friday. So as a judge, if you're feeling like you want to look on a Tuesday or Friday, you can look and see if you've been reversed today. So sometimes you want to avoid that though. So I don't have anything else. I think I've exhausted the time I've been allotted, so I'm not going to ask about questions. But thank you for your time and attention, and I hope something I said is useful to you in listening to the argument today. And I hope you enjoy the opportunity that not many high school students in the state are privileged to have. So you are now ready for the Supreme Court. Thank you. Go with it.
Morning. On behalf of the Nebraska State Patrol and the Minden Police Department, I would like to welcome you to the Nebraska State Supreme Court. I'd like to announce right now that this room is now a courtroom. Along with that, there comes certain rules. Number one, there is no cell phone usage. If you have a cell phone, please make sure that's on silent and it's turned off. Okay? We don't want to have a competition to see who has the most obnoxious ringtone here today. Anyway. Also, please, no photography unless you've been pre-approved prior to court beginning. Also, there will be no talking as well. On behalf of that, I'm Captain Mike Roberts, Nebraska State Patrol, Capital Security Division. The reason why we are here in the Minden Police Department here is not only to keep the justices safe, but to keep you all safe. So let's turn this into a really good opportunity, and welcome to Minden.
you. You may be seated. Please raise your hand if you can hear me. Good. Thank you very much. We will begin this morning with introductions from the court. I am Mike Hevican, and I am the Chief Justice. And now, by order of seniority as to service on the court, the other members of the court will introduce themselves.
Good morning, I'm Lindsay Miller-Lerman.
Good morning. My name is William Castle.
I am Stephanie Stacy. Good morning.
Good morning, I am Jeff Funk.
I'm Jonathan Papik. Good morning.
I'm John Freidenberg. Good morning.
Thank you, members of the court, and I should also introduce our bailiff, Allie Stewart, is here this morning. We have a special bailiff, and that is Jesse Tunnell from here in Minden High School. So welcome to you, Jesse, and thank you for your service, and thank you, Allie, for your service. Again, good morning to everybody, and thank you to Minden High for hosting us here today. And we only have one argument this morning. We had two, but we had to cancel one. Things come up, and a lawyer couldn't make it. So we have one case this morning, and it is entitled Williams versus Frakes. And Mr. Susi, good morning to you.
Good morning.
Mr. Smith, good morning to you. Do either of you have any questions before we begin?
No, Your Honor.
Thank you very much. These are two veteran attorneys, so I didn't think they would have questions, but they don't. So, Mr. Susi, you may approach, you may proceed. I wonder if there's some way that we can kind of share that also with the audience. I don't
I don't know how we can do it.
Got it.
I didn't know how the setup was going to be.
That's
Mr. Chief Justice, members of the court, when I heard about this, I accepted the invitation to come to Minden because I happen to have grown up 20 miles south of here, and my fifth grade teacher, as she thought I ever would have appeared before the Nebraska Supreme Court, case must have been Captain State versus Gerald Seuss. But I spent the entire fifth grade essentially in detention, battling with her, and the way she kind of turned me around was word problems. And word problems were a math problem, and I just loved it. I mean, it ended up turning me around, and I realized when I did all of that what I have here today is a math problem. And the question is, in a math problem is, what is it that you're trying to find out? And with these three sentences, the question is, how much time can the state of Nebraska require Justine Williams to serve on each of the individual sentences? And then, if they're combined, how much can the state of Nebraska require her to serve? That's the question. And when you do that, it struck me that there are two ways that you can try and add these together. And that's what this chart is about.
Mr. Susi, on what grounds did the district court deny?
They denied it because I had a stated cause of action, and I couldn't get relief under 9/11 or civil rights violation.
And do you contend the district court was wrong?
Absolutely.
And why?
Because it's a constitutional violation. You can't decide the jurisdiction before you consider whether or not the merits as alleged state a constitutional violation. And what I'm trying to show is that in fact there is a constitutional violation because the Department of Correctional Services, in computing the amount of time that Justine Williams has to serve, exceeds their statutory authority by 3 years.
So the trial court never reached the math problem that you are presenting because it concluded that the manner in which you were presenting the math problem was wrong. The vehicle you used to present the math problem was incorrect.
Yes, and they did it, and the district court did it both under 9/11 State Administrative Procedure Act and under 1983, which is incorporated in. And my point is that the allegations alleged that she was going to be incarcerated beyond her mandatory release date. And a mandatory release date, once you reach that date, by statute, by the 8th Amendment, by the 14th Amendment, you get out of prison.
What's the relief you're seeking in this lawsuit?
Well, I would like a remand. I'd like a remand with instructing them what the law really is.
Well, I don't mean in this appeal, in the underlying lawsuit you filed in the district court. What's the ultimate relief that the lawsuit seeks?
I apologize. The ultimate relief is going to be that the Department of Correctional Services determines the tentative release date in compliance with the law. We are not challenging the validity of any of those three sentences.
But an earlier release date, correct? An earlier release date than what the DCS is currently calculating.
Yes, but it's not an earlier release date than what is required by the sentences that the judge imposed, all three judges.
If we were to disagree with you and conclude that bringing this case for this purpose is not viable under the APA or 1983, what are your options?
Federal court.
Or could you bring habeas in state?
I can't bring habeas. Here's the problem. That's what Mr. Smith has suggested, is that you sit around and we wait until habeas. So I file habeas, if I'm still alive, in 2023, the day after it's filed. What's going to happen? They're going to have 30 days to answer. Then the judge is going to sit on it.
You said 2023?
I said, so I'm in 2033. I apologize. 2033. And then, because I can't file until she's entitled to absolute relief, we claim she's entitled to absolute relief. She will spend then a year, maybe a year, 12 months. That's what happened with Barney Meyer, where I had the same situation where he was being held illegally. So then what happens? If I win then correctly with the issue I'm presenting today, Mr. Smith has put the Department of Correctional Services into the position of now they're subject to a civil rights violation for having incarcerated Justine Williams for a year, longer than is necessary, and they don't have immunity. They're stuck with individual liability. Now, they may get indemnified by the state, but that's something that 1983 contemplates by allowing you to go in and say, hey, there's a potential constitutional violation about to take place. I don't want to wait until that constitutional violation has occurred. I suffer my damages, and then I got to sue the people that are keeping me in prison longer than I'm entitled to.
When specifically do you think the client should be released?
What is it, February? That's what on here, February. It's 3 years ahead of what the state does. And what I've done with this chart is that there are two different ways of doing it. You do them individually. If you do them individually, you have the first one, second one, third one, and when you add them together, you get a discharge date of, let's say, November 25th, 2033. The state says November 25th, 3036. Now, in addition to what happened,
2036.
say, I'm sorry,
2036.
2036.
I don't think any of us are going to be around at 36.
But you cure the problem before it exists, and she suffers no damages. Now,
What do you, excuse me, if we were reaching the merits and working the math,
yes,
what is the first sentence that became final in your view?
oh, I think they're all final.
Which is the first?
The first one was final, well, when the appeal was decided it started July 1st, 1999. It became final when the direct appeal was decided in 1995. I mean, that's technically,
Let me try to tease out some of the
yes,
counts and so forth. Is this correct? She was convicted on a weapons charge?
yeah, that was.
And that was never changed, is that correct?
Never changed.
Regardless of the resentencing for the
Yes.
the juvenile offender?
Yes.
So is that the day one? That weapons charge,
For
the
the
sentence hasn't changed through time, correct?
Okay, those dates are set forth in statute, specifically 83-1106, which says that in computing the sentence, it begins on the date that the individual enters the institution. It doesn't begin on the date she's convicted, it begins on when she entered the institution, and that was July 1, 1994. That's the operative date. Everything goes from July 1, 1994, and the issue is how long from July 1, 1994, based on those three sentences and the term that attaches to each of them, can the Department of Correctional Services keep her until she's entitled to her mandatory release. That's the word problem. And to do that, you have two ways of doing it. You can say, okay, I'm going to figure out what the maximum time is that you can hold on each of the one individual sentences, which is what I did on the top. And that gives you the discharge date of November 25th, 2033. The other way I did it is say, okay, let's don't do them individually, let's put them all together. And that's what I did on the bottom. I took all of the years of the sentences, combined them, and then deducted the credit for time served, which includes the credit granted on the first sentence and credit on the second sentence, and you come up with the same date, November 25th of 2033. And so when you get to that date, how is it that the sum of the parts, according to the Department of Correctional Services, requires a discharge date that is 3 years beyond what the math shows you when you add them individually, and the math shows you if you combine them together. And by making that argument on the substance, that is why she should be able to pursue this in a 1983 action, as well as in an Administrative Procedures Act action, because the threatened application by the Department of Correctional Services violates her rights, which is the right to be released once she's completed her sentence. Thank you.
Thank you very much. Mr. Smith, good morning to you again.
Morning, Your Honor.
You may proceed.
Before we proceed, could you take the exhibit down so I can maybe to see?
Thank you.
Mr. Chief Justice, members of the court, may it please the court, I'm James D. Smith, a Senior Assistant Attorney General for the Attorney General's Office in for the state of Nebraska. I represent the appellees in this case. I'm going to just slightly digress on my oral argument. I did want to compliment the court, compliment the school administration for having oral arguments here in Minden. This is a very impressive school auditorium. It's my understanding it's been in existence for about 7 years. Years ago, when I first started practice of law, I did practice law in outstate Nebraska. I practiced law in this part of the state for a little over a decade. I tried cases in the district court at the courthouse in Minden, tried cases in front of the late Judge Irons. I tried cases in front of the late Judge Sprague. They were both excellent judges. I learned a lot from them. Very good memories. I do appreciate the opportunity to be back in Minden for another court case, as obviously I'm getting closer to the end of my legal career. With that having been said, I want to start my legal argument. My legal argument makes two main points. First, the district court correctly dismissed the appellant Williams' lawsuit because Williams did file the wrong causes of action to challenge the prison's calculation of her mandatory discharge date from prison. Second, this court should dismiss this appeal for lack of jurisdiction because the case is not ripe. I'm going to address that second point first because an appellate court cannot decide a case if it does not have jurisdiction over it. This case is not ripe. Williams claims her mandatory tentative prison discharge date should be 10 years from now, not 13 years from now, as calculated by prison authorities. Her lawsuit was filed in December of 2022. It's now before this court for decision in less than 1 year. And part of the reason for that is this court's docket, as we all know, is very current. The court, unlike maybe what the public reads in other places, this court does not have a case backlog. It disposes of cases, decides them in a timely manner. This lawsuit is simply premature. Williams assumes nothing's going to change over the next 10 years on the law or the facts. And I would submit a lot can happen in a decade. And if we go back in time a decade, we have Miller v. Alabama, we have State v. Mantage, we have Montgomery v. Louisiana, which cases decided that juveniles under the age of 18 cannot receive a mandatory life sentence in prison for first-degree murder. Because of those cases, that's why we're even here, because Williams pursued those cases, took the appropriate remedy, relief, and her mandatory life sentence, and she was, for a crime committed as a juvenile, was vacated, retroactively became void, and she was resentenced. All of that happened in the past decade, which shows a significant change in the law. The assumption...
What's your position as to when this case would become ripe? Does she have to wait until 2033, someday shortly before that?
Well, what I would submit is, one, she does have the remedy of habeas, which obviously is going to be ripe if she says, I should have been released and I'm still in prison. That's obviously ripe. The other thing, I think it has to be a lot closer than 10 and 13 years from now if she wanted to actually file the proper lawsuit, which would be under the Uniform Declaratory Judgment Act, which she didn't even file in this case. And what the ripeness doctrine requires is that there has to be a concrete legal dispute susceptible to specific judicial relief as distinguished from an advisory opinion regarding contingent future events. In other words, she's assuming nothing's going to change on the facts, nothing's going to change on the law the next decade, and her entire case is based on assumptions of contingent future events, which means it's not right.
So you, I think, just said she would have to file the declaratory judgment action closer to the deadline. She thinks she should be released. How close would she have to be?
Closer than a decade. And I think this court could simply say, you don't have to say exactly when that point is, but I think you can certainly say it isn't now. It's not a decade away. In 1958, I would say nobody was expecting in a decade we would have men on the moon. Things happen, facts change, law changes. The unexpected happens over a period of a decade. And the assumption that this court should just decide this case now, you just have to make a bunch of assumptions that the facts and the law is not going to change over the next decade, and that's contrary to the rightness doctrine. It should be dismissed for no jurisdiction.
Assuming that the ripeness problem was somehow surmountable, what is the state's position with respect to the applicability of a 1983 action in this, under these circumstances?
The district judge, our position is the district judge was correct. He correctly articulated that 1983 action cannot happen because of the United States Supreme Court decision Wilkinson v. Dotson, that the 1983 lawsuit can't be used to challenge the duration of confinement, which is exactly what she's doing. Also, I would say under Schaefer v. Frakes by this court, alleged violation simply of state law without more does not rise to the level of conscious shocking the conscious support due process claim. The district court got it right that the 1983 action that he's pled, he tried to get attorney's fees under that, but Wilkinson v. Dotson just simply says that's a non-starter. The court also, district court was also correct in saying the other alternative cause of action that he filed was under the Administrative Procedure Act, not the Uniform Declaratory Judgments Act. And the APA would grant immunity to the state because all the department was doing was a construction of applicable statute, court law. It's not a challenge to any agency, regulation, or rule. And so there's no waiver of government immunity. I would cite the Heist case for that, which also would for recurring for the same principle.
The trial judge alluded to, and in brief, at least your brief implied that there is a remedy potentially available that was not asserted in the complaint that was before us. Is that right?
That's correct.
Would you, if not for our benefit, for the benefit of the students whose education is being fostered by our questions and your answers, explain about that?
One could file a lawsuit under the state's Uniform Declaratory Judgment Act, which essentially involves declaring the rights among disputing parties. That type of a lawsuit, if you filed it simply against the government, state government, the state government is immune from that type of lawsuit. However, that type of a lawsuit can be maintained against state officials individually, as opposed to like the state of Nebraska or a state agency. He did not file that type of a lawsuit under the Uniform Declaratory Judgments Act. Instead, he filed it under separate statutes, the Administrative Procedure Act, which under the Heist case, the state of Nebraska is immune.
Under the 1983 action that you've been referring to is a federal statute. What's the purpose of that federal statute?
The purpose of that federal law, statute is to allow someone to say, you violated my federal constitutional rights, and so you could file a suit under the 1983 federal statute, not Nebraska state statute, seeking relief under that federal statute, and you can do that in a state court. Your relief could include damages, it can include a declaratory judgment, but the starter is you have to have a violation of a federal constitutional right. It's not simply claiming, I disagree with the state's interpretation of its own state laws. It has to violate federal law.
What would be the viability of habeas and when? State habeas?
State habeas is viable once the person has reached the point that they should be released from prison and they're still being wrongfully held in prison beyond their mandatory release date, then you can file a state habeas action, and there's state statutes allowing a state habeas action to get a court to say you're holding this person beyond what the law allows you to do, and you're hereby ordered to release the person from prison. It might be premature, but probably not under Heist. One perhaps could make the argument because of the state habeas statute, that is your sole remedy. I would leave that for another day.
For educational purposes, we refer to a habeas action. That's shorthand for habeas corpus. Can you enlighten our student audience as to what that means?
Habeas corpus is a Latin term. When I was a law student, I used to have professors that say when courts start speaking Latin, it's because they can't articulate it in English, but that's where that comes from. But it's a Latin term essentially involving the fact that someone is being wrongfully held in custody by government, by prison, or whatever, beyond the time that the law allows them to keep them in
Wouldn't the
custody.
literal translation be produce the body?
Produce the body, that's the Latin translation, yeah. Produce the body, take them in front of the court, and then the court decide whether or not you should be released from custody or remain in custody. And if the court, and it's a fairly summary procedure, it's supposed to be, if the court does not order the release, then you have a right to appeal, and eventually that appeal can come to this court. But as I indicated before, this case is going to be decided in roughly a year. So it's not, doesn't take 10 years or 13 years to get to the Nebraska Supreme Court to get a decision.
Before you sit down, to help this group better understand what this matter is all about, can you help us understand why the state says that this appellant owes 3 more years of incarceration than she thinks she does?
It's a combination of state statutes. She got convicted of first-degree murder when she was juvenile. She was sentenced to life in prison, and under that, you don't get out of prison at all unless you're granted a pardon or clemency or something like that. She also was given an additional prison sentence for use of a deadly weapon or a firearm in the commission of that felony, which was on top of her murder sentence. And then while in prison, she got 1 more prison sentence for assault by confined persons. In other words, while she's in prison, she assaults somebody else. That's the background. The United States Supreme Court decided Miller v. Alabama and said as a matter of constitutional law, you cannot sentence a juvenile under the age of 18 to a mandatory sentence of life. Nebraska law.
So she's resentenced on the murder.
She's resentenced on the murder.
Was she ever resentenced on the weapon?
She was never resentenced on those other 2
So
crimes.
was the weapons the first day, that was the first sentence that became public?
Yes, the weapons sentence would have been at the same time as the sentence on the murder for which she was resentenced. The assault on a confined person was later. Then it gets into issues of how you construe the statutes on
But we're not going into LV 191 and 250, whatever.
No.
But I'm just trying to hear what the state believes is day 1 for doing the proper
Well,
calculation.
what I would say, as a matter of law, the district court never decided that substantive issue because the wrong vehicle was used to try to address it. And I think that would be a matter, if the court disagrees with my argument and sends it back to the district court, then it's up to the district court to address that substantive issue, which it never decided, so I'm not going to presuppose what the district court should do, nor would I think this court.
If you were going to presuppose, what would your argument be?
My argument would be I prefer Schaefer v. Gable, in which you consolidate all of those sentences, because essentially what the defendant is trying to do is the same thing the defendant tried to do in Schaefer v. Gable, and that's eliminate those other prison sentences and get credit for time served twice. and essentially say, I got resentenced to life, I got all the time credit for time served back to when I was first arrested for that murder case, and then all of these other 2 crimes should just disappear and go away, and so I get credit for time served twice. That's what happened in Schaefer v. Gable, and this court said, no, you can't do that. The court has further questions. I would conclude by, one, asking the court simply dismiss the case because it's not right. And the alternative, if the court's not going to do that, I would ask that the district court's decision be affirmed.
Thank you very much. Mr. Susi, we gave Mr. Smith quite a bit of extra time. We'll give you a minute and a half, and maybe want to rebut.
Number one, I have never, ever said that the mandatory discharge date, the tentative discharge date, means he has to get out of prison at that time. If she violates rules, if she loses good time, that can be extended. The problem is when establishing the tentative release date triggers other parts of the statutes regarding how she will be housed when she becomes eligible for parole, when she's eligible to move from NCCW to community corrections. So it's a big deal to wait for whatever the Goldilocks period of time is when it's proper to raise this.
Would it be possible, for example, that this triggers eligibility for parole? Would it be possible for you to bring the lawsuit at that point?
Well, she's not eligible. I mean, yeah, if she's eligible for parole, I think this lady's gonna make parole compared to what the other juveniles are. But she's not eligible for parole. And it's,
you can calculate the time that you think she would be eligible if the sentence would be like it.
if it was computed the way I think it needs to be computed, she's been parole eligible in 2016. We're a little late, all right? But I know that I can't allege parole eligibility as being a constitutional violation. I have to go after the mandatory release date because parole is a discretionary matter, even if the number's wrong. Thank you.
Thank you very much. Council, that concludes arguments in Williams versus Frakes. And that therefore concludes our arguments for today. So the court is adjourned. And you may, council, you may stay around. We're going to have questions and answers from students, and you may stay around if you wish, or you may proceed for the rest of the day. We'd like to thank you for being here and taking part of this. We want to apologize to everybody. We had a second case lined up now. So we all got here one case this morning. And this is kind of the procedure that we will be following. We will take questions from you for a while. We cannot talk about the case that you heard today, so don't ask us any questions about that case. It would be unethical for us to speculate about anything within the case to you off of the comparable case. But we certainly will take other questions from you about the legal profession or procedures the court follows and so forth. So we're going to do that. Before we start, I want to say we've got students here not only from Minden High, but also from Kennesaw, Franklin, Axtell, Hastings, Bertrand, Wilcox, Hildreth, and Blue Hill. And if I left any schools out, I apologize to you, but we are very excited that you are all here today. And we again thank Minden High for hosting us and for bringing in students from all of those nearby high schools. With that, if someone has a question, please come forward. And do we have
If you want to just raise your hand, one of these gals with the
mics and bring them around to you.
Very good. You have 2 minutes. Yes, ma'am. You might get your name first and then your question.
I have a question.
Okay, good.
Are you able to change the time from the timer on the podium from where you're sitting, or do you have to do that manually?
I can't see the time, so you have an advantage over me. Normally, I can, in the Supreme Court courtroom, I can see the time. But today, what I can see is the lights on the podium, so I can tell, for example, when arguments are getting close to the 10-minute limit, the yellow light comes on, and then when the red light comes on, I know the time is up. And we try to be, or I try to be reasonably fair with people. We ask Mr. Smith a number of sort of extra questions, so even though Mr. Susie's time for rebuttal was really used up, we try to be fair, and so we try to balance that out.
Thank you, Your Honor.
Yep.
There was another case today that was given a continuance. Does that happen often, or why might that happen?
That happens not infrequently, and so we try to work with lawyers. In this case, a lawyer had a child in the hospital, pretty serious medical issue, and we just simply did not think it would be fair to demand that they come out for an oral argument. So stuff happens, and so we give continuances, but folks have to show good cause. You can't just make up.
They're pretty rare in the Supreme Court. Trial courts, continuances are very frequent.
Thank you, Your Honor.
Thank you.
Are you guys appointed, and if so, who are you appointed by?
Very good. Are we appointed, and if we are appointed, who appoints us? Anybody?
We are appointed initially by the governor, but there's a step before that in the state court system. To be eligible to be appointed by the governor, you have to go through what's called a judicial nominating commission. And that's true for judges on the Supreme Court, but all other state court positions in Nebraska. Judicial nominating commissions are composed of lawyers, but also lay people. And their job is to decide who they believe is qualified to serve as a judge. So in order to be appointed by the governor, a judicial nominating commission first has to find you qualified, and then the governor can appoint from those candidates. After that, after we're appointed in the state court system, we also have something called retention elections. So when you go to vote, at the very end of your ballot, there's a list of judges, and the question that's put on the ballot is, should Judge so-and-so be retained in office? Yes or no? And as long as that judge gets more yes votes than no votes, they continue in office. And if they would get more no's than yeses, they would be removed, and there would be a vacancy for the governor to fill. Those retention elections happen the first election 3 years after you were first appointed, and every 6 years after that.
Thank you, Your Honor.
Did your question also include not just what officer makes the appointments, but specifically for each of us, who the governor was that appointed us? Is that what you were asking?
Yes.
Well, here we go.
Well, here we go, because I've been on the court the longest, and that was Governor Minden.
Oh, Governor Ricketts appointed.
Governor Ricketts appointed me to the Supreme Court. Governor Heinemann appointed me to the district court bench before that.
Governor Heinemann appointed me to the Chief Justice job 17 years ago.
Governor Heinemann appointed me to the Supreme Court 11 and a half years ago. 8 years before that, Governor Johans appointed me to the Court of Appeals. And 12 years before that, Governor Nelson appointed me to the District Court bench, which is the bench that Judge Harder is a member of.
Governor Heinemann appointed me to the county court bench, the district court bench, and Governor Ricketts appointed me to the Supreme Court.
Governor Ricketts appointed me to both the county court bench and the Supreme Court.
There you go. So we've got a variety of governors, some of whom were governors before we were even born. But that's kind of how the process takes place. And I would add that many states elect their judges. I believe 26 states elect judges, some on a nonpartisan basis and some on a partisan basis. In some states, judges actually run as Republicans or Democrats for their position. Nebraska used to elect judges on a nonpartisan basis, but that changed in the early 1970s. There was a constitutional change that everybody voted into place, so we have the merit selection process that you just heard about.
I was about your age when it changed.
Uh-oh.
This is a safe question. Can you explain to them the Judicial Nomination Committee, who's on it, how they get selected? I think that's important.
Yes, that is important. So the nominating commissions are made up of 8 people. I do not know why they settled on an even number of people to do this, but there are 8 people. 4 of those people are lay people. 2 of those, this is a little bit of an oversimplification, but 2 of those have to be Republicans. 2 of them have to be Democrats, and they are all appointed by the governor. Then there are 4 lawyers on each of those committees, and those lawyers, 2 of them have to be Democrats, and 2 of them have to be Republicans, and a little oversimplification. But the lawyers are chosen by other lawyers from the particular district that we serve in. So that is the process, and I will make some more comments on this. Our system gives the governor a lot of power in shaping the judiciary. It gives local lawyers also considerable power. It gives the legislature no power whatsoever, and it really gives the judiciary no power either. We have little or no input into who are going to be fellow judges with us. So it's an interesting process. Other states have a little bit different spin on the merit selection process, but that's what we have here in Nebraska.
For those of you that are interested in history, this system is called the Missouri Plan, but we're actually more Missouri than Missouri because Missouri never applied it to all of their judicial positions, and since 1972, Nebraska has applied it to all levels of the state courts.
You heard several folks refer to lay people on the nominating committee. That just means citizens. It means non-lawyers. So 4 citizens, politically neutral, and 4 lawyers, politically neutral. Sort of vet the applicants and send a short list to the governor of those lawyers who they think would be qualified.
To be a judge, you have to be at least 30 years of age. You have to be a lawyer in practice for at least 5 years, and you have to be a citizen of the state of Nebraska.
And the United States.
Yes. Would be if you were a citizen of the state of Nebraska.
And eventually, when you're sworn in, you have to live in the district. Okay, other questions? Yes, ma'am, way in the back.
Me? Okay, my name is
is Georgia, and I heard this within the arguments, but it's not about the case itself. I want to confirm. Well, hearing the arguments, I heard about an oral argument. Are there different types of arguments that can be used in the courts?
Okay, everybody.
Yeah, yeah. So before we got here today, we considered a different kind of argument, and that is argument submitted on written briefs. And so when a case is appealed, the party who's taking the appeal files a brief that lays out the things that party thinks were done incorrectly by the trial court, and annotates it, if you will, supports the argument with case law and statutes and whatever else that party thinks is going to support their argument. Then the appellee, the other side, gets an opportunity to file their written argument, their brief, and they do the same thing. We read those briefs before we come to an oral argument, and we review the record that was created in the trial court. And so all of those arguments are considered before we even get together to hear what you heard today, and that's the oral argument. Oral arguments are made in trial courts too. It just means spoken, right? It just means it's not a written argument, it's an oral argument.
And one other thing about that is our rules require that all of the grounds upon which someone is challenging the lower court's decision have to be set forth in those written arguments. The lawyers can't omit something from the briefs and then show up for oral argument and try to raise it then.
I have an extra PPS here on the discussion, which is just to distinguish oral argument and the other manner in which cases are disposed. And this pertains more to the Intermediate Court of Appeals, not us here at the Supreme Court. The case can be decided on the written arguments without an oral presentation. That happens more at the Court of Appeals than with our doc.
Thank you so much.
Thank you. Good question. Okay, we've got a question here.
As America has been becoming more politically divided, how do you deal with political questions on the Nebraska Supreme Court?
How do we deal with political questions on the Nebraska Supreme Court? As carefully as we can.
All of us, I've heard Judge Funk at similar occasions explain, and I will echo what he has said. All of us take an oath to uphold the Constitution and laws of the United States and the Constitution and laws of the state of Nebraska. And our personal views are not what we're supposed to be deciding cases on. We're supposed to be deciding it on what the law requires and not how we hope it comes out. And that's one of the things that when one becomes a judge, one inevitably faces cases in which you wish the law was different. But that's not our role. Our role is to uphold what the legislative branch has enacted, or if they have gone beyond the bounds of the Constitution, to strike down those laws which conflict and go beyond the constitutional powers of the legislature.
The cases that come before us, when they're decided, we will typically write an opinion that explains our decision. Part of that is to help the parties, the litigants, understand what we decided. Part is to help future cases, lawyers and other litigants who have similar facts and similar issues of law to understand what they should expect in their case. And part of it is to reassure the public that when we made our decision, we didn't make it just because we're from a certain part of the state or we have a certain demographic or something of that nature. We try to explain that we base it on the facts and the law of the case. And hopefully that gives some impression to the citizens of the state that we are not deciding it improperly. We are deciding based upon the laws passed by the legislature and the facts as the trial court has found them to be.
So part of that is to reassure the public that we aren't making those decisions in public.
Very good. Next question. He's got a microphone. It's ready to go.
He's ready to go.
Yeah, what are your guys' hobbies?
Well, I still have children in high school and middle school, so my hobbies still revolve around them. I coach a lot of youth basketball, and that takes up a lot of my time.
I no longer have kids in high school, so I don't have any hobbies, and I gotta figure out what they're going to be. But I, like all of you, enjoyed high school football games. My daughter played high school volleyball, and all that played basketball, so enjoyed those types of things. I think we all enjoy being involved in our communities the best that we can. We're limited by our roles. We can't always participate in some of the things we'd like to participate in, but that's why I think we get to do some of these things where we meet you and speak with you and share our passions about the law. It's kind of a hobby for us, an opportunity to fill that void that we don't get to do on a regular basis.
Very good. Anybody else want to jump in there?
Go to a lot of Nebraska football and volleyball matches. The last home football game that I missed, other than COVID, which is an exception, was the weekend my son was born, and he will turn 44.
Interesting to add to this process. The job obviously keeps us pretty busy. So my hobby is being with friends and so forth.
Oh, you want an answer? Okay, well, gardening in season, kids and grandkids, and that would fill up all the days if you wanted.
My husband and I have 4 kids, and they're all grown. And as I listen to all my colleagues, I'm thinking how boring I am, and I'm trying to think what my hobbies are, and I'm not sure I have any. But when I have free time, I like to ride my bike across the state. So maybe that's a hobby.
I have 3 kids that are still in school, and for a while my hobby was coaching, one of them basketball. But this year, Judge Freidenberg is actually coaching my son, so I've turned that over to him so I have more time to find a hobby. I just gotta find out what that's in.
He's very good at delegating.
There you go, hobbies. Now we get a question.
Hi, Simon's Brody from Kennesaw. How does being a judge impact your life? And besides reviewing cases, what do you do on a daily basis when you're not hearing them?
Very good. So the combination of your question, how does being a judge impact your life? Well, you just heard a little bit about that with hobbies. And when we're not hearing cases, what are we doing?
Well, changing from an attorney to a judge, there's a significant social difference. When you're an attorney, you basically have options to socialize and interact with others without many restrictions whatsoever. But once you become a judge, you have to pull back from a lot of those relationships and everything, so you maintain at least the appearance that you're not leaning one way or the other, or outside factors are affecting your decisions when you're here. So one of the biggest changes that occurred is that it's a little bit of an isolating feature. You don't have as big a social group as you once did before.
So you've heard about the written arguments, and a lot of what we're doing when we're not in court or we're not writing an opinion is reading. We read thousands of pages to get ready for oral argument. We read the record that was created below, we read all the written arguments that were submitted, and sometimes we read them once or twice or 3 times. So there is a lot of readings that happens between oral argument sessions. That's, I'd say, reading and research and writing is primarily what we're doing when we're not in court. We also, all of us have administrative duties because the court system doesn't run itself. And so when we are not doing our decision-making as Supreme Court justices, we are working on different administrative matters for the courts.
There's way more administrative things that you haven't thought about, but you actually do know exist, and they take management. The court has the probation department within it. We have issues and solutions for interpreters. We have attorney discipline. We have to make rules. We have to admit lawyers passing the bar. So on the administrative side, it uses a lot of time.
Very good. Next question. Okay, got a hand way back.
I think we have one right up front.
Okay, we got one up front.
How many years of schooling did you guys go through in order to become a judge?
How many years of schooling did we go through to become a judge?
7. So we have 4 years of undergraduate degree and then 3 years of law school. 7 years.
There are some programs now, in fact, I think Judge Son is considering it, a 3-and-3 program where you do 3 years of undergrad and your 4th year of undergrad counts as your 1st year of law school. In some law schools will offer that. So you can shorten it by a little bit if you're high achieving and you work real hard.
Well, I'm not sure that all of them qualify because I was a 3-and-3 years ago, so I'm not claiming the attributes. 6 years in my case.
And believe it or not, there is a shortage of lawyers in the world today, particularly in the rural areas of virtually every state, and certainly here in Nebraska. So the law schools and everybody else involved in the legal profession, everybody is working very hard to try to recruit folks for the legal profession, and especially folks who will return to places like Minden and Kearney and Scottsbluff and so forth to practice law. So one of the lessons we hope that all of you learned today is that the legal profession has all kinds of potential and is very interesting, so we would prefer that you all become lawyers. We suspect that may not happen, but for those of you who are interested, there are lots of programs now to make it less expensive and programs for you to get through the process more quickly. Hence the 6-year programs we're talking about.
The judicial branch has 1,200 employees, something of that nature. Not all of them, obviously, are judges. So we have lots of opportunities for you to work in the judicial branch. Probation officers, Judge Miller-Lemon mentioned that the Nebraska Supreme Court oversees state probation. So if someone's in trouble, they're going to put on probation, probation officers supervise that individual. Those officers work for the Nebraska Supreme Court. The judicial branch, we have courthouses in all 93 counties of the state. In those courthouses, we have clerks, we have court reporters, we have potential bailiffs. So there's lots of ways that if you're interested in working for the judicial branch, you can do that beyond just being a lawyer. We'd love to have you all go to law school and then work in rural parts of the state and then become judges someday. That would be great for us. But realistically, there's only so many spots, and we need you in other places as well. So keep in mind, if you see at a job fair or a college fair, the state probation office or the courts, go stop by and talk to us and let us give you some advice or some information about the job opportunities. We just did a probation swearing in yesterday for new probation officers, and they range from probably 22 years of age to 45 years of age, all shapes and sizes from all parts of the state. 12 judicial districts, and we have probation officers in all those judicial districts. So please keep us in mind when you're thinking about college, you're thinking about your careers. We have a lot that we can offer.
Very good. Now, we've only got time for a question or two left, and so we've got the gentleman back.
What is your favorite or most rewarding part of the job?
What is our favorite, most rewarding part of the job? Well, I usually take this opportunity to say our favorite part of the job is visiting Minden High School. But what I really mean with that is one of our favorite parts of the job, and members of the court may have a different answer to this, but one of my favorite parts of the job is getting out, visiting with people in the system, having sessions like this where we meet law, where we meet high school students, and we get a lot of interaction, and hopefully you learn something from this process. We always learn something from this process. And we do other things during the year. In the summertime, we have a summer tour where we visit a certain part of the state and go to different courthouses, law associations, and get input from folks about how things are going in the front lines, if you will, with our courthouses. And again, we always learn a lot from that, but we've tried over the last 10, 15 years to make the court system more open. So our oral arguments, for example, are webcast live. I'm not sure we did that today, but we did it today. And we do that definitely during the Supreme Court courtroom. The Court of Appeals does that too. So we have oral arguments once a month. And you can watch those live on NET, which is broadcast by Nebraska Public Television. And we now have gotten our trial courts to allow TV cameras, just regular cameras into their courtrooms and radio stations and so forth. That can make things more complicated from courts, but we think that it lets the public see what is going on in their courts. The Constitution says the courts will be open. In the 21st century, that has a technology component to it. And we think it's important that folks see what's going on, and that's really important. And I think that it's paid off for the court system very well. So we've got about one more question. I see a young man down here. He's got his question. Okay.
So,
you got the microphone.
what advice would you give to a student thinking about a career in law?
Okay, what advice do we have to give to students who want a career in law? Any?
So, a lot of you play games at home, right? You have a family game night. If you are the kind of person who grabs that box lid and reads the rules, the law might be for you. If you think you might be interested in the law, you can try it out in high school, right? There are mock trial teams that you can be a part of. There are debate teams you can be a part of. Theater, a lot of folks who go on to law school have a background in theater. There is a lot of theater that happens in courtrooms all the time. Anything that you can do to practice public speaking, thinking, anything you can do to practice disagreeing with someone civilly, right? Listening to the other side, thinking about the issues from the other side. One of the most fun things we get to do in our job is look at all the issues from the different perspectives. You heard today, one side views the facts one way, the other side views the facts a different way. The judge or the decision maker has a different perspective. So lawyers get practiced and judges get practiced at looking at one issue from a whole lot of different angles. Practice doing that. Read as much as you can read, learn as much as you can learn, and always leave space in your thinking for the possibility that you might be wrong and you might not know everything. Work hard in high school, do your best, and then you can study anything you want to in college and still go on to law school. You can have any kind of bachelor's degree So do whatever interests you as an undergrad, and then take the LSAT and give law school a try.
I would suggest, and those are great suggestions, Judge Stacy, but I would suggest as well to get involved in the legal field by reaching out to lawyers in your communities. Reach out to the judges in your community and say, can I come watch you for the day? Can I come to court? As the chief said, courtrooms are open to the public. They're learning environments for all of us. Take that opportunity and go to court. See what happens there. Get to know the people that are in the courts, the lawyers, the judges, the clerks. Start communicating with them. Those people they're proud of their jobs. They're proud of what they do. They want to share that with you. We have a county judge here today and a district judge. If you reach out to them, I think they'd be happy to have you come shadow them and see what they do in the day. Once you start building those relationships, then you've got the inside track. Now you've got somebody that's done it, and now you can reach out to them and say, well, now I have this thing to do. How do I do that? How do I fill out an application for college? How do I fill out an application for law school? What are reference letters? Who should I get a reference letter from? What classes should I be taking in school? If you've got people that have made that journey already, reach out to them and let them help you, guide you on your journey so that you can be successful and get to where you want to go. Don't have to reinvent the wheel. Use the people in your own community who would be more than willing to help you reach those goals.
Anybody else want to jump in on that? With that, we would love to stay here.
We would like to have a picture with the student ambassadors, the student bailiff, gentleman, and I'm sorry I forgot your Sam, and then the student media person. If we could do that before the court gets on the rules.
Absolutely. We can do that. We're happy to do that. We would love to stay longer and answer questions, but so again, thank you very much, Mim and I, for hosting us. We will do some photographs. Thanks, everybody.
Aaron. We good?